Hello friends, so this is part 2 of general law on legal theory for CS students. So hello everyone, today we will learn about legal theories, which is a branch of jurisprudence or the study of law. So legal theory helps us understand what law is. Okay. So why it is exist and what role it plays in society. There are many ways to think about law, but we will focus on some key theories and important legal thinkers. Okay. So first question is, what is legal theory? So legal theory is a like it is about understanding the foundation and nature of laws, and two main kinds of legal theories are positive legal theory and normative legal theory. So positive legal theory explains us what the law is and how law come about and how they works in real life, and normative legal theory tells us what the law ought to be and how laws should be to make better society. There are also other perspectives like sociological theory, in which we discuss law and society, economic theory, in which law and economy is involved, and historical theory about the history of laws, and critical legal theories about law and power. Various thinkers and jurists provided the definition of law, but there are certain limitations in their definition of law. Jeremy Bentham was the pioneer of legal theory. Bentham saw law as commands made by a sovereign. Sovereign means a ruler or government to control people's behavior. According to him, law is a set of rules issued by the sovereign governing what people should or what shouldn't do. So, the purpose of law is to promote the greatest happiness for the greatest number of people. So, law should ensure common good, not just individual desires. Bentham divided law into 8 parts. First one is the source of law, means from where the law originates. And second one, on whom it applies to. What are the subjects, means individuals on whom the law applicable. And next is its goals, which is like what are the objectives of law. Next, where it applies, means the extent of law, and the nature of the law means its aspects and the force behind obeying it, also the remedies given by courts, like in case of infringement of those rights, those laws, what is the remedy available, and the how the law expresses the sovereign's will. So these all are the 8 parts into which the law is divided by Bentham. In the criticism of Bentham's theory, we can say that Bentham treats law narrowly as commands and ignores law that gives power, like making contracts is a power derived from law. And next, it doesn't fully respects custom and judge-made law. But nowadays, customs and judge-made law are also law. And his pain pleasure idea for deciding law is a subjective and hard to apply objectively. And increasing happiness for some may reduce the happiness for others, which his theory overlooks. Okay, now let's take John Austin's theory of law, which is also known as command theory. So Austin builds on Bentham's idea only and said that law is a command of sovereign backed by sanctions, and sanctions means punishment. The main point of his theory is first one is law, which is command from sovereign in power, and second one is like there must be a sovereign who is obeyed by the people, but he obeys no one. And the third one is that sanctions, that law have sanctions, and sanctions means that whoever not following the law must be punished. That are the sanctions. In the limitations of Austin's theory, that Austin doesn't cover laws that give rights or benefits like welfare laws, and modern governments are limited by constitution and international laws, so how they can be sovereign? So the sovereign isn't absolutely supreme nowadays. So judges sometimes creates law, but Austin didn't acknowledge this, and international laws don't fit in his theory well because there is no single globe sovereign is there. The next one is Salmon's theory of law and justice. The Salmon saw law as a body of rules recognized by the state to achieve justice. He made a distinction between the law and law. So the law is abstract, the overall system of rules and principles, but in law it is concrete, specific laws like the Right to Information Act. He believed the main job of law is to deliver justice by maintaining order and fairness. While laws are important, but sometimes the administration of justice can sometimes happen without fixed law also. For example, sometimes with the help of fairness and equity, we achieve the desired results. The criticism of Selman's theory is that not all laws bring justice. Some laws can be unjust also. Next is law serves many purposes beyond justice. So there may be certain laws which does not provides only justice, but purpose may be something else. And next is his focus on national law limits the broader concept of justice, because justice is a concept which is universal, not limited to a certain place only. Next is Roscoe Pound. He is known for his social engineering theory. Pound compared lawyers to engineers who built society. His idea that law should create an efficient society where people's needs are met with minimal conflict. So he categorized interests that law must balance into three groups. First is individual, second public, third one is social. In individual interest, he provides like personal rights like privacy, family, and property. In public interest, he provides rights like community and state interest. In social interest, it's like general well being, social order, morals, and progress. So, Pound thought laws should balance these competing interests fairly. On the belief of Pond that interest exists before law, but critics says that some interests are created by laws themselves. Next is like there are no clear guidelines to weigh or measure competing interest. So this is another criticism, and his theory gives judges a lot of power in deciding which interest is most important. Next one is distinctions made by him between public, social, and individual interest is not very clear, which is also one of its critiques. Next thinker is H.L.A. Hart. He provided modern legal positivism. So Hart argued positivism means law is a system of rules which is separate from morality, such as law consists of rules created by authority, and judicial decisions can logically follow from these rules, like without considering the social aims or morality. And law as it is should be separated from law as it ought to be. So this is the theory provided by H.L.A. Hart. Next is Hans Kelsen. He provided the pure theory of law. Kelsen wanted to remove all morality and politics from law and make jurisprudence a pure science. So he said law is a hierarchy of norms like rules where each lower rules get authority from a higher one. At the top of the hierarchy is the grand norm or basic norm which is accepted without question. Next point is like according to Kelson, laws are valid as long as they conform to the grand norm. For example, all laws in India should be in conformity with the Constitution of India. So, and legal orders creates unity because all norms can be traced back to this basic norm which is Constitution in India. This pyramid is explains the exact situation. In the criticism of Kelson, it is like it's hard to identify the grand norm in real legal systems, and his purity of pure theory breaks when we analyzing the grand norm, because outside factors come inside grand norm like sociology and morality, so it is not basically very much pure, and international law doesn't fit very well in his like in his as countries prioritize their own laws over international rules, but still international law is a law. That's all for today. Thank you so much.